Imagine you've poured your heart, maybe a big chunk of your savings, into a stunning property in, say, Phuket. A gorgeous villa with those amazing ocean views, maybe a condo right on the beach, or even some land you're planning to build on. It's your dream, right? But then you start thinking, what happens next? What happens to that dream, that investment down the line? It can feel a bit like trying to put together that flat pack furniture without any instructions, really confusing, and maybe not ending up how you wanted.
That's a great analogy, actually.
Well, today we're diving deep into exactly that,
Yeah.
Thai property inheritance, a foreigner's guide. Our mission today is basically to untangle Thai inheritance law, specifically for foreigners. We've pulled the key insights from a really comprehensive guide by Ocean Worldwide, their luxury real estate agency, actually based right there in Phuket, been there since 2004. Yeah, and they've helped literally thousands of families and investors figure this stuff out. Their director, Sandra O'Neill, really gets the luxury market in places like Phuket and Koh Samui. So we want to flag some surprising bits, give you clear takeaways so you don't feel, totally lost. Okay, let's get into it. Planning for the future isn't simple, especially with assets in a place like Thailand.
And what's really fascinating here, and honestly often a bit of a jolt for foreigners, is just how different the legal landscape in Thailand is compared to maybe what you're used to back home. We'll be exploring the sort of rule book for estates here.
Okay.
That's mainly guided by the Civil and Commercial Code, but we also need to look at the Land Code Act that's super critical for foreigners, and the Revenue Code, which covers inheritance taxes. It's a layered system. It aims for clarity, but yeah, it can feel quite rigid if you haven't planned ahead.
So let's start right at the basics.
Yeah.
The core framework of Thai inheritance law. It's important to get that this covers everything, right? Whether you have a will or not.
Exactly.
And it applies to all kinds of property, bank accounts, cars, that incredible villa, the condo, everything.
That's absolutely right. The foundation, the bedrock, is the Civil and Commercial Code, sections 1599 to 1654 specifically. But you hit on a key point. What if there isn't a will? That's where things can get, surprising for many. Without a valid will, what we call intestate succession, Thai law doesn't really care about your informal wishes or who you felt closest to. It just steps in and dictates a very specific, quite rigid hierarchy of statutory heirs.
Okay, here's where it gets really interesting and probably, like you said, a shock for some people. Who actually gets what if there's no will? It's not about favors. It's this legal pecking order, right?
Yeah.
Can you walk us through that?
Precisely. And this highlights those system differences. Thai law sets out 6 categories of statutory heirs, and they inherit in a strict sequence. If there's anyone in an earlier category, they inherit, and the later categories. They get nothing. Doesn't matter how close you were.
Wow.
So the order is, first, descendants. That's your children, grandchildren, if your children have passed. Top of the list.
Right.
Second, your parents. Third, siblings of full blood sharing both parents. Fourth, siblings of half-blood. Fifth, grandparents. And sixth, uncles and aunts.
Okay.
And there's also this per stirpes principle. It basically means if an heir who is supposed to inherit has already died, their kids step into their shoes and inherit their share.
Ah, okay. So it stays in that family line.
Exactly. It prevents a whole branch of the family from being cut out unintentionally.
Now, what about the surviving spouse? Where do they slot into this hierarchy? Because, a lot of people just assume the spouse gets everything automatically.
That's a huge misconception and, really critical for foreigners with assets here. A surviving spouse is a statutory heir, yes, but their share isn't always the whole pie. It actually depends entirely on who else is in the picture.
How so?
Well, for instance, if there are children descendants, the spouse shares the estate equally with them.
Equally.
Yep. If there are no kids, but say parents or full-blood siblings are alive, the spouse usually gets half the estate. Only if there are absolutely no other statutory heirs in any of those 6 categories does the spouse inherit everything. So thinking about securing maybe a luxurious 5-bedroom oceanfront villa in Kamala, Phuket, just relying on assumptions without a will, that could lead to unexpected co-ownership, maybe even disputes. It makes distributing an estate without a will pretty complex, needing very precise legal steps.
Right. So it sounds like if you have a specific plan for your assets, especially that lovely Phuket villa, just letting this default pecking order take over, well, it might not match your wishes at all.
Not even close, potentially.
Which brings us neatly to the power of having a Thai will.
Yeah.
When it comes to protecting your assets here, Having a properly drafted will seems pretty essential, doesn't it?
Oh, absolutely essential. Now, foreign wills can sometimes be recognized in Thailand, but honestly, it's often way simpler and more effective to have a will made specifically under Thai law for your Thai assets.
Why is that? Just smoother.
Yeah, think about it. A foreign will usually means getting it translated, certified, authenticated by courts. It can take a long time, add stress for your family when they least need it.
Right.
A Thai will, especially for things like a beachfront condo or maybe that 1.25 ray plot near Surin Beach you mentioned earlier, it just streamlines the whole process.
Yeah.
Thai law recognizes a few types.
Okay, like what?
The most common is a written will. You sign it, and crucially, you need at least 2 witnesses present at the same time to sign it too.
Gotcha. 2 witnesses, same time.
Then there's a holographic will. This one has to be entirely handwritten by you, the testator. No witnesses needed for that one.
Handwritten, okay.
And you also have public wills made before a notary public, which gives them a bit of extra legal weight. Oh, and there are oral wills, but they're really only for specific emergency situations, not practical for planning.
And who can make a will? Any
Sure.
restrictions?
Pretty straightforward. You just need to be at least 15 years old and, of sound mind. So yeah, if you want that land near Surin Beach to go to a specific person, a proper Thai will is definitely your best bet for making sure it happens smoothly.
That makes a lot of sense. Just simplifying it for everyone involved. Now, it's not just about houses and land, is it? Different assets might have slightly different rules, like what about condos or company shares? Lots of people invest in those here.
You're absolutely right. The type of asset really matters. For condominiums, while foreigners can generally inherit them, there's that big catch. The 49% foreign ownership quota for the whole building.
Ah, yes. Heard about that.
If inheriting a unit means the building goes over that 49% limit for foreign ownership, the heir might actually be forced to sell it within a set time frame. It's not just a suggestion, it's a legal requirement.
Okay, so that's a potential hurdle. What about company shares?
They don't just automatically transfer. The heirs have to go through a formal process. They need to present all the paperwork, death certificate, proof they are the heir directly to the company to get registered as the new shareholders, keeps the company record straight.
And what about something less tangible, like a long-term property lease? Maybe for a shop or even just a house.
Leases are interesting. In Thailand, they're usually seen as personal contracts. So typically, the lease just terminates when the tenant dies.
Really? It doesn't pass on?
Not automatically, no. It often catches people out. It could be inherited, but only if the lease agreement was structured very carefully from the start to allow that, and you have the landowner's explicit consent, which honestly is pretty uncommon. In most cases, if an heir wants to keep using the property, they'd have to negotiate a completely new lease with the owner. So this is definitely an area where getting solid legal advice before you sign any long-term lease is, well, it's a must. For you and for your potential heirs.
Okay, right, not that. Let's talk about what many foreigners call the biggest potential headache, the landmine of Thai property inheritance. Owning land directly. This is where it gets really tricky if you're not a Thai citizen, isn't it?
Indeed. This is probably the single biggest difference from many Western systems, and yeah, often the source of the most confusion and stress for foreign heirs. The basic rule is clear. Foreigners generally cannot own freehold land directly in Thailand.
Period.
Pretty much. And that restriction applies directly to inherited land, too. The law aims to keep most land owned by Thais. So if you're a foreigner and you inherit land, maybe it's a lovely 4-ray plot out in Thalong, Phuket, you typically have a very strict 1-year window.
Year. From when?
From the date you officially inherit it, and within that year, you must dispose of it. That means either selling it or transferring ownership to a Thai national, maybe a spouse or another family member who qualifies.
And if you don't manage it within that year?
Then the land department can step in. They have the authority to sell the land on your behalf. And they'll likely keep a fee, usually around 5% of the sale price, for their trouble.
Wow. So it's not a suggestion, it's a hard deadline with real financial consequences.
Exactly, a strict legal deadline.
A 1-year deadline for dealing with land that feels incredibly tight. Are there any exceptions, even rare ones?
They're extremely rare. There are provisions for getting special permission from the Minister of the Interior to own land, but it usually involves very specific circumstances, maybe certain treaty agreements, or sometimes for foreigners bringing significant investment under specific Board of Investment programs.
So not for the average person inheriting a plot?
No. For the vast majority of foreigners inheriting land, the only practical routes are selling it or transferring it to a Thai national within that year. Understanding this upfront is just crucial if you own land or might inherit land in Phuket or anywhere in Thailand.
So what does this boil down to for you, the listener? Essentially, yes, you can inherit land as a foreigner, but you usually can't keep it long term. That clock starts ticking right away, which makes all this talk about proactive planning feel suddenly very urgent.
Very urgent indeed.
Okay, so when someone passes away, obviously their assets need to be managed, distributed properly. This is where an estate administrator comes into play. Think of them as the person put in charge of sorting everything out, like the conductor for the estate orchestra.
That's a perfect way to put it. An estate administrator, or an executor if they're named in the will, has quite a lot on their plate. Their duties are pretty broad.
Like what specifically?
Well, first, they have to create a full inventory of all the deceased's assets, usually within a month of being appointed. They absolutely must keep the beneficiaries informed throughout the process.
Okay, transparency is key.
Crucial. They manage the estate day to day, handle court matters, collect any debts owed to the estate, pay taxes due by the estate, and then, finally, distribute what's left to the rightful heirs. It takes meticulous attention to detail, impartiality, and, yeah, a huge amount of trust.
That does sound like a heavy load. What if the administrator isn't, doing a good job? Can they be removed? What can the beneficiaries do?
Yes, absolutely. The law provides for that. Section 1727 of the Civil and Commercial Code is the key here. If an administrator is negligent, maybe dishonest, or just isn't managing things effectively, any interested party, usually an heir, can ask the court to remove them.
At any point.
Pretty much, yes, before the estate is fully settled. And administrators can also resign themselves, but they need the court's permission and a valid reason. The courts really prioritize protecting the estate, so they'll step in if there are concerns about things like hidden assets or just general poor management.
Okay. So how does someone get chosen for this role? Especially if there's no will naming an executor, and what paperwork do you need to even start this process?
If there's a will naming an executor, the court usually respects that choice, assuming the person is willing and able. If there's no will, or the named person can't or won't do it, then the heirs, or sometimes even a public prosecutor, can petition the court to appoint an administrator.
And the court decides who?
Yes, and their main criteria are trustworthiness and capability. For owners living overseas, it's definitely possible to appoint someone living in Thailand, maybe a local representative, but you have to be incredibly sure they're reliable and will be transparent.
Right. And the documents.
The usual suspects: the death certificate, proof of the deceased residence, marriage certificate if relevant, often a family tree to show who the heirs are, consent forms from the other heirs saying they agree to this person being administrator, all the documents for the assets themselves, land deeds, bank books, car registration, and of course, the will, if one exists.
And roughly how long does this whole administration process take, from applying to actually distributing the assets?
It definitely takes time. Getting the administrator appointed might take, say, 3 months for the court application, maybe another month for the final court order, but, and this is a big but, if there are disagreements among the heirs or legal challenges, the whole thing can stretch out considerably, potentially well over a year. I've seen complex cases take several years if the disputes are really intense. One slightly positive note for people overseas: while you traditionally might have needed to be physically present for court hearings, some Thai courts are now allowing online proceedings more often. That can make managing a Phuket property inheritance a bit easier logistically for international heirs.
That's good to know. Now, sometimes things get even more complicated, don't they? Beyond just appointing someone. What if, say, a property was owned jointly? Or we're not talking about land or villas, but maybe cars, bank accounts, any specific wrinkles there?
That's a great point. Assets aren't all the same. With joint ownership, there's a common misunderstanding. People often think if two people own something and one dies, their share just automatically goes to the survivor.
Yeah, that sounds logical.
It does, but it's often not the case in Thailand unless there's a specific legal agreement, like a right of survivorship clause, or the will clearly states it. Usually, the deceased person's share just becomes part of their estate, which means it gets distributed according to the inheritance laws, or the will. So the surviving co-owner might suddenly find themselves sharing ownership with heirs they barely know. That can definitely complicate things.
I can imagine. And what about movable assets, cars, bank accounts, investments, personal stuff?
They fall under the same general inheritance laws, but the actual transfer process is different for each. Cars need specific paperwork filed with the Department of Land Transport. Bank accounts usually require the death certificate, maybe a court order or grant of probate, before the bank will release the funds.
Okay.
And it's really important to remember the value of all these movable assets gets added to the estate's total value when calculating any potential inheritance tax.
Right, it all counts. And what happens if, despite best efforts, the family just can't agree? Maybe about who gets what or how things are being handled. How are disputes typically resolved?
Disputes can definitely happen, unfortunately, especially if wishes weren't clearly documented. Thai law does have ways to handle conflicts. The first step, and usually the best one, is mediation.
Mediation.
Yeah, getting a neutral third party involved to help the family negotiate and hopefully reach an agreement everyone can live with. It's generally faster and less expensive emotionally and financially than going straight to court.
Makes sense.
If mediation fails, then legal action might be the next step. That could mean petitioning the court to interpret an ambiguous will, or maybe challenging the administrator's actions. But honestly, the best way to avoid most disputes, or at least make them less likely, comes back to that proactive planning.
The will again.
Exactly. A clear, well-drafted tie will drastically reduces the chances of fights, making the whole inheritance process for that Phuket property much smoother. It lets your loved ones focus on grieving, not on legal battles. Getting professional legal advice early on is always the smart move here.
Okay, so let's quickly recap the main takeaways from our deep dive today on Thai property inheritance for foreigners. First, it seems pretty clear. Having a valid Thai will is highly recommended. It helps ensure your wishes are actually followed and just simplifies things hugely for your family. Don't just assume things will work out.
Absolutely. Don't assume.
Second, yes, foreigners can inherit property, but remember those strict limits on owning land directly. You often have that 1-year deadline to sell or transfer it. Be ready for that. Crucial
Right.
point. And maybe the biggest takeaway, talking to a qualified Thai lawyer isn't just a good idea. It's pretty much essential if you have assets in Thailand. They can help you navigate the law, stay compliant, and really protect your estate and your beneficiaries. It's all about being prepared, right? So your wishes are respected and your loved ones aren't left trying to assemble that impossible flat-pack furniture without the instructions.
Which really brings up a key question, doesn't it? Especially knowing how unique Thai inheritance law is for foreigners. What steps would you, listening now, take today? What's the first thing you do after hearing all this to make sure your own estate plan actually reflects what you want and protects the people you care about from headaches down the road?
Thinking about that peace of mind, not just for you, but for them, especially when you're dealing with assets in another country. It's pretty invaluable, isn't it? It's really a gift you can give them and yourself.